SwayamPrabha. Digital India. Educated India.
Welcome students. Today I am going to discuss lecture number 5 under Transfer of Property Act. Earlier we have seen about the rights of unborn person. Myself, Dr. Amarendra Kumar Ajit, Assistant Professor of Law, Senior Grade, Faculty of Law, University of Delhi. So, today discussion topic is vested interest and contingent interest under Transfer of Property Act. So, what I am going to discuss subtopics within this, just I will tell you about it. So, what I am going to cover today is, that is vested interest, prior interest, nature of vested interest, transferable and heritable interest, kinds of contingency, nature of contingent interest, and difference between contingent interest and space successness. So, first come to the vested interest. What is the vested interest? It says that under the Transfer of Property Act, there are different types of interest we used to discuss. But one thing is very important, when we transfer the property, there are the transfer of interest. Because in previous lecture I have already discussed that in case of transfer of immovable property, there is no transfer of property per se. That means physical property will remain at its own place. Only the right related to the property is going to be transferred. And in same way, when that right is going to be absolutely transferred, when it is going to be accrued, it depends upon the interest, and these two interest is related to this one, that when actually the transferee will get the whole right about the property, when the property has been transferred. So, it depends upon the various nature of interest. Within that, this vested interest and contingent interest, they are very important and very conceptual, that you must understand that when the transferee will be able to enjoy the rights once it has been transferred to him. So, in that case, from this point of view, it has been said that the quantum of this right or interest may be absolute or partial. So, when this quantum is going to demarcate the time of accruing the whole interest, okay, when the transferee is going to get interest. So, where the interest is transferred is vested, the transferee get the interest immediately. That is the basic fundamental difference. In the beginning itself, I want to tell you that if interest is vested, then this property right will be transferred immediately. When the interest is contingent, then right will be subject to certain incident. That means, there is no transfer of ownership immediately, there is no transfer of rights related to that property will not be vested in case of contingent interest. But if there is a vested interest, that right will go. Again, I want to differentiate here that vested interest and that right transferred related to the property and enjoyment of the property, both are different thing. You should not understand that once the right has been transferred, the same meaning is that the whole enjoyment related to the property have been also transferred. It is not the case. It may be case simultaneously that interest has been transferred, vested interest is there, so enjoyment rights has been also transferred. But sometime it may happen that vested interest had been transferred, but enjoyment rights will come later on. So, we should not merge this at this stage at the very beginning itself, that there should not be confusion that wherever there is a vested interest, transfer of property is happening immediately. So, transfer of property is happening immediately, but it is not necessary that enjoyment of the property will also happen immediately. It is not the case. It may come later on, and we will discuss all these things about this in this lecture itself. So, in other words, as soon as the transfer is complete, the interest accrues to the transferee with immediate effect in case of vested interest, and transferee's title is complete. What is the meaning of transferee title complete? That means transferee title has been already given, that means title has been gone to the hand of transferee. Okay, so, right has been already gone, and in that is an immediate transfer. Okay, and this immediate transfer is different from the contingent interest. So, in that way we used to see this, it is transferring the property immediately. Later on it may be possible that enjoyment rights has been also transferred immediately, or it may come later on. So, when we talk about the vested interest, then what are the essential requirement? The interest created in favor of transferee is said to be vested when no time has been specified as to when or it take effect. The first essential is when it will be presumed that this transfer is vested. Sometime there may be possibility, that nothing is written in agreement. Okay. Then what will happen? Then it has been said that if the time is not mentioned, that when this property is going to, or rights is going to be given, meaning thereby it will have it will take effect immediately. Okay. And it is to take effect upon happening of event which must happen, all these things. So, three things are essential. First, if it is not mentioned that when the this rights is going to accrue, by default it will be presumed that this is the vested interest, and this vested interest has transfer immediately. Another is that once it is written in that it is immediately it is going to be transfer, it has been transferred immediately. In that case also it will be presumed, it may be written, it may not be written, but practically if it is already enjoyment has been given, then meaning thereby there was a vested interest. And third thing is very important here, that happening of must event. Happening of must event is a main criteria, and we will see this through example. So, this vested interest is a kind of presumption by law. What is the presumption? That if the transferor does not specify as to when the interest shall accrue to the transferee, okay, then law will presume, and the presumption is law of part of the law of evidence. So, you might have seen that there are different kinds of presumption. Okay, that it has been said that if there has no any date specified in the agreement, that when the rights will accrue on the part of the transferee, then there will be presumption by the court that it has been already transferred, all rights has been transferred. So, in that way it is taken. More specifically, it has been said in other hand, in order to be more specific, transferor may express his intention that interest shall accrue to the transferee with immediate effect. That means, second thing is that when it is written in the agreement that okay, from this date to this date the transfer is happening this, and this will take immediate effect, or there may be certain circumstances which may be mentioned in the agreement itself which may result with the immediate effect. So, sometimes it may be very date specific, sometimes it may be that how it has been drafted, that it is giving the immediate effect of the rights, transferring the rights. So, in that way this is the second condition. Third is that if something is going to happen certainly, okay, and that has been mentioned as a condition in that. So, in agreement if something has been mentioned in that, then also which is going to happen or bound to happen, okay, that certain date in future bound to happen, certain year in future bound to happen, okay, death of a person bound to happen. Okay. So, there is certainty. So, even in that case it will be treated as vested interest. So, the third category it says that in both the cases interest transfer is a vested interest, where the transferor provides the transfer shall take effect upon happening of event must nature. This is must nature is very important, must nature, because if any event you are saying that where there is a possibility of not happening, then it will not come under this category. Must nature is bound to occur in future, then also this interest will be called as vested interest. The best example is certain date is bound to come, just like it will be mentioned that January, February of next year like this, certain death of a particular person of this, that means property will be transferred after the death of this particular person. So, death is also certain. Okay. So, if the certain events are happening or mentioned there, happening of that event is mentioned there in the agreement, in that case also right will be treated as it has been transferred immediately and there is a vested interest. So, the interest towards the property has been vested, that is the meaning of this. Then next is it says that for example, any future date or year, any particular age of the transferee or death of any person. So, any age of transferee if it is also mentioned, that is bound to happen. Okay. Then where the transfer of property is to take effect on the death of person, the interest accrues to the transferee immediately, being a vested interest. So, it may be noted that the death is a certain as birth, where it is provided that property is transferred upon the death of the person, interest of the transferee is invested, because although death is a future event and it is certain. So, future event which is certain, future event which is bound to happen, that will fall under that category. So, enjoyment will be postponed in this case, enjoyment will be postponed in this case, right has been transferred. That means, this property has been transferred to the person, it with immediate effect, that means he will be treated as owner. He will be treated as owner. Only thing is that this vested interest is there, and this vested interest is going to convert with the full enjoyment of the property only after happening of that certain event. So, this is a third category, but in first and second category, that where it is not mentioned, the date is not mentioned in agreement, then it will have immediate effect. That means, there is a vested interest plus full enjoyment of the property. In that case, if there the date is mentioned, till that date there is a vested interest, after that date it will be full enjoyment of the property. In third case, where the events are mentioned and event is bound to happen, in that case till the event is going to happen, up to that time it is vested interest, and after the event happened, then the full enjoyment of property will go to the transferee. So, these are the three conditions where vested interest can be identify that during the transfer of property which kind of interest has been transferred. Okay. So, now come to through some examples. So, first is A makes a gift of his house to B. He simply executes the gift deed, but does not specify any date on which the ownership is to be transferred. Then it is going under the first condition, and interest of B is vested interest and it is immediate one, whereas in case this second example, A makes a gift of 10,000 rupees to B on death of C, B has a vested interest on rupees 10,000 even before C dies, That means there is a vested interest before the death, but he will not use these 10,000 rupees. He will be not able to use these 10,000 rupees. Why? Because 10,000 rupees will be given only after the death of C. Okay. So, but money shall be paid to B only upon the death. So, enjoyment of those 10,000 rupee will come after this, after the death. So, in that way, if it is vested, because death is certain, so it is vested. If B dies before the death of C, B, that means the person B dies before the death of C, the money shall be paid to B legal heir. Okay. B, if B dies before the death of C, the money shall be paid to the B legal heir. Why it is going to be paid? We have not seen in that kind of the case in unborn person, right. Here it has been says that now the property has this rupees, because these sections are applicable to movable as well as immovable property. So, if person has already transferred that money with an agreement that okay 10,000 rupees I am going to give, but after the death of this person C. So, what will happen? The right has been created. Against whom? It is a kind of contract. So, now the B will have right, that because the property has been transferred to B or rupees has been transferred to B with condition after the death of C. So, now B will have right over 10,000 rupees, 10,000 rupees, the right has been created. Enjoyment is postponed because he has not the possession of those 10,000 rupees, it has been not transferred to him. So, if C dies, then B will take 10,000 rupees, A will give, because gift is there, condition has been fulfilled. Second thing is that if B dies, because these rupees or property has been gifted to B. So, if B dies first prior to C, so what will happen? Whether this vested interest will continue. So, here it has been said that if B dies first, then B dies first and C is going to die later, but in condition C death is essential condition, because after C death only this property is going to be given to B. So, this vested interest has been created in B, and B, because now B has died. So, B legal here will have those vested interest. Now, what is the characteristic? You will see these vested interests are inheritable in nature. Okay. So, now this B legal here after the death of C will claim those 10,000 rupees. Okay. Or it will same happen with the case of immovable property. So, these are the vested interest, that means property has been transferred immediately, right has been created immediately, only there was the postponement of enjoyment of the rights, otherwise right has been transferred. Now, come to the next thing. So, explanation of section 9, which is mentioned in the Bear Act, makes it clear that vested interest is not affected by the fact that the right of enjoyment has been postponed. So, explanation of section 19 is very clear. Okay. This explanation what it says, that the vested interest remain unaffected also when the title is to pass on another person on the happening of a particular event in future. Okay. So, this enjoyment is postponed, and postponement of enjoyment of the rights on movable or immovable property will not affect the transfer of right. Okay. So, in that way vested right will always remain intact in that case. Next is enjoyment postponed. Thus, so explanation to the section that interest shall not be a vested interest is not to be inferred merely from the provision, not to be inferred merely from a provision whereby the enjoyment of property is postponed. A condition postponing enjoyment does not prevent interest from vesting immediately, but it is itself void for repugnancy after the transferee has attained majority. Okay. So, enjoyment postponed, that means after certain time this enjoyment should not be postponed. Okay. Because right has been vested, if the future incident is happening which is bound to happen, till then only it is postponed. A condition postponing enjoyment does not prevent interest from vesting immediately. But what is void? But what it says that it is itself void for repugnancy after the transferee has attained majority. That is very important. No one can make condition in that even after the attaining the majority of the minor, there will be no full enjoyment of right. No one can say. That means, in agreement it cannot be given that the person will take enjoyment of right after 21 year or 22 years. No. Once there was happening of the things, that is after reaching the majority age, it will be automatically it will go. But if the condition has been put that 19 and 20 and 21st year, so this is against the law, and in that case it has been said that this kind of postponement is not permissible, it will be void. Okay. So, there is a very important case in this, that is the Lachman versus Baldev. Okay. In that case, a person transfer a deed of gift in favor of another person, but directed him that he would not get possession of that property until the transferor himself died. Okay. The transferee will have a vested interest even though his right of enjoyment is postponed. The gift was subject to the death of the donor. Okay. And in that case, this is the subject, and donor death is certain condition. So, it is the when it is a certain condition, in that case it will be vested interest. Repugnancy arises in such a situation when there is an inconsistency between two rules. Okay. Inconsistency between two rules, what are those? That through illustration we will try to understand. Where A transfer property to B in trust for C, interest is important, and directs B to give possession of property to C when he attains the age of 25. Okay. What I have explained just now. So, C has a vested interest and is entitled to possession at the age of 18. Why? That when this inconsistency will arise. Now, the future condition is attaining the age of 18, 25, as well as this is a future condition in the deed itself. And for the trustee, A transfer property B in trust for C. Okay. So, B was trustee for the property and it would have been transferred to C when he will attain the age of majority. So, when he is attaining the age of majority as 18, but the in condition in the deed was 25 year. Okay. So, this 7 years gap, that is from 18 to 25 year, which was undue kind of thing has been put in the deed. So, that will hamper this movement of property. Okay. So, law says that it was for the minor in that case, and then only it will attain, it will give, it will have, he will take full possession of property just after the 18-year, not after the 25-year. Clear? So, C has vested interest and is entitled to possession at the age of 18. Now, come to this concept of prior interest. Okay. Prior interest, some part where to some extent we have discussed in the right of unborn person. So, more or less that same type of the things, that if in between there are some person who are holding the property as a prior interest person, then how this will go in the case of vested interest. So, similarly, it is not to be inferred that interest shall not be vested merely by provision whereby the prior interest in the same property is given or reversed for some other person. Where a prior interest is created, there is only a postponement of enjoyment, okay, postponement of enjoyment, not the vesting subsequent interest, not the vesting subsequent interest. Okay. For example, it is has been given here, where A transfer property to B for life. So, B for life is a kind of, B for life is a kind of prior interest. Then to C, okay, here the interest of C is vested interest, okay, but only due to the prior interest created in favor of B, his right of enjoyment is postponed till the life of B. Okay. So, one thing is we have seen in the third condition of this vested interest, what we have discussed, that now things are going to happen. It has been said that property has been transferred to C by A, but in between B person is holding the property. We have seen this kind of the example in unborn person case, that a grandfather is transferring the property to grandson. Okay. In between father or some person is only the prior interest. So, property has been transferred, no doubt at all. That means, once it has been mentioned in that gift, okay, or this transfer will, then it has been transferred to that extent, except the enjoyment is postponed. Enjoyment is postponed, that means, this grandson would not enjoy the property unless the attainment of majority, or unless this up to the death of Mr. B. Okay. If the death of Mr. B is the condition, then majority will not be a role. Okay. That grandson may be of 20, 30 years, but in between B is the life, this with prior interest holding the property. In that case, B, this C will have no enjoyment right. So, this is the postponement of enjoyment right. So, generally it serves the purpose in Hindu family or within the family itself, that the property has been already transferred, but it will be not enjoyed till the person is in middle person, that is the person with the prior interest, are not going to die. So, property is also safe, and ultimately it is going to be vested into the this or enjoyment is going to be done by the Mr. C. So, in that way both interests serve in that way, interest of B also sometime and interest of C. Now, accumulation of income, okay, whether it is a kind of vested interest or not. Why accumulation of income here it has been kept specifically, okay. That means, once the property has been given or transferred to someone just with a prior interest or some other kind of arrangement, then during that period, that means till the final stage of the this property is going in or going to be possessed by the ultimate transferee, till then there will be income from that property. So, that income is accumulating, and in between he cannot take, the final transferee cannot take that accumulation of income, because enjoyment is prohibited by certain conditions, but right is vested. So, in that case what will happen? So, it says that it is not to be inferred that interest shall not be vested, whereby income arising from the property is directed to be accumulated until the time of enjoyment arrive. Okay. So, it says that this accumulation of income must be within the limit sanctioned by section 17. If the direction is for a period in excess of the period specified, it will be invalid for the period in excess. Only the right of enjoyment is postponed only, but not the vesting. Okay. So, in that way this interest shall not, it says that it should not be inferred that interest shall not be vested. That means, the interest which is coming, that means the property which is income which is arising from that property, on that income also there is a vested interest. Okay. It should not be treated in that way that there is no vested interest over that accumulation of interest itself. So, accumulation of income also come under the vested interest. Then certain conditional limitation, which is generally put under the agreement at the time of vested interest. What is the nature of that this conditional limitations? So, these interests shall not be vested is not to be inferred from the provision that is a particular event shall happen, the interest shall pass to another person. Such type of provision is known as conditional limitation. That means, interest shall not be vested is not to be inferred from provisional, or if a particular event shall happen, the interest shall pass to another person. Okay. The condition limitation divests an estate that has become vested and vest it in another person. What is the meaning of this? Meaning is very simple. We are already explained the third condition, that a person is creating interest, person has created interest with certain condition, that this condition is will fulfill, then only it will go. Then here it is saying that those interest, the condition which has been created, this condition is a kind of conditional limitation is there. This is called conditional limitation, and this conditional limitation is not a restriction in the vesting of interest. Okay. So, conditional limitation here, conditional limitation you can say that we can divide into this if conditional limitation is not affecting the rights, or you can say vested interest, vested interest. There is no effect on vested interest, conditional limitation, it is only over the enjoyment. Okay. Enjoyment of property. So, conditional limitation is one of the criteria within the agreement itself, whose effect will have no effect on the no effect on the vested interest, where will be it will have effect over the enjoyment of property. So, in that way it works. Clear? Now, next point. So, a conditional limitation divests an estate that has become vested and vest it in other person. Okay. So, divesting means one is vesting, another is divesting. So, interest has invested into that person. When this condition will come, this earlier I have just said that this is a condition, this condition has been put. So, vested interest is this side and this side is enjoyment of property. So, after this happening of this condition, this vested interest is going to be divested. Divested, that means now full property with full right has been divested to the person against whom that right has been made. So, divesting of the vested interest result into the full enjoyment of the property. So, this is the one of the case and it should not. Okay. So, this conditional limitation also mentioned under this section 28 of TPA, and I will discuss in a different lecture this conditional limitation. Okay. Next lecture. So, that conditional limitations is different from this one. In Sundar Bibi versus Rajendra Narayan, the term of a compromise provided that L should have an estate for life. L should have an estate for life, and after his death R to be full owner of estate. That means property was going from this a person A to L to R, full owner of estate. Okay. If he survive L, that means if R is going to alive after the death of L, then this was the condition that A made a deed according to that the L was with only the prior interest and whole property was going to be shifted to this R. So, certainly R had vested interest when this has been made by A itself, but enjoyment was restricted. So, it has been said that L should have an estate for life, and after his death R was to be full owner of estate. Okay. If R did not survive L, that means R is going to die during the lifetime of L itself. The estate would pass to R lineal male descendant according to the rule of primogeniture. Okay. That means this R has already died during the lifetime of L, but because it was the vested interest, then he had already created a right in this. So, their legal heir will get the property after the death of L, not during the lifetime of L anyway. Okay. Because the condition is after the death. So, whole enjoyment of right will be transferred to R or legal heir of R's only after the death of L. So, before the death of L, the question arose whether R had only contingent interest or vested interest. Okay. So, in this question it was arose that before the death of L, that means before the death of L, what was the nature of right of this person R, because whether it was a vested or contingent one. If the provision had been merely this, that the estate would pass to R. Okay. Now, how it has been drafted, the importance of the drafting is very important. Word of drafting is very important. How it has been drafted and how the nature of rights will also change accordingly. So, it is very important. So, here it has been said, you will see that is the provision had been merely this. If the provision would have been merely this, the estate would pass to R if survive L and nothing more would have been said. Then there can no doubt that R would take the estate contingent on surviving L. Okay. If now you will have to differentiate here that when it is a vested and when it is a contingent. So, again come that if what would have been the condition, the state would pass to R, a state, that means a state what A is going to make, A's state is going to pass to R if he survive L, and nothing more would have been said, nothing more would have been said, then it would have been a contingent one, then it would have been a contingent one. So, there can be no doubt that R would take the state contingent on the surviving L. Okay. Then this would have been a contingent one, but here what has been said that R was to be full owner of a state if he survived L, and if R did not survive L, the estate would pass to the this R's lineal male descendant. Okay. So, the drafting of agreement or drafting of will, drafting of any testament is very important, that how it has been drafted and what kind of the rights might have been created. So, L should have an estate for life, and after his death R was to be the full owner of estate. So, this estate what is making difference here in these two condition, it is about putting L with the prior interest, okay, putting L with the prior interest. So, that is making different. Here what has been written, the L should have an estate for life, and after should an estate for life, that means L is holding the estate for his own life, that is important, and in that way it is creating a vested interest. If only the condition would have been happened that this right will pass to R just after the death of L, then it would have been a contingent interest, because it is creating a kind of condition that after the death of L only property will be transferred to the R. Okay. Prior to that there is no such kind of creation of interest. Okay. So, if that will be the case, then it will be contingent one, because it is putting a condition that property will be transferred only after the death of particular person. But here not merely the transfer of property with a condition of death, it has been said the person who is holding the property with a prior interest, that is important one. Okay. So, once the prior interest has been created in between, okay, the prior interest, and then it is going to be next one, then it is a vested interest. Okay. So, you can say that in certain conditions like this, vested interest will prior interest will follow the vested interest. Okay. Prior interest will follow the vested interest. So, this is possible only in third condition, otherwise in the first two condition when nothing is mentioned it will be immediate effect, where date is mentioned there will be immediate effect. Clear? So, further the provision of a gift over another person was a condition limitation which has been affected the vesting estate in R. The court gave the reasoning that the condition affected the retention of the interest and not in its acquisition. R looks a vested interest liable to be divested if he did not survive well. So, it was a kind of vested interest. Now, come to the contingent interest. Okay. This contingent interest is mentioned in section 21 of the Transfer of Property Act, and this is different from the vested one. So, we have seen this contingent interest has a different meaning and different repercussions also. So, the vesting interest in favor of ultimate beneficiary may be postponed till his minority. Okay. That means, till he becomes a major. Therefore, between the period the last person having prior life interest dies and the unborn who is ultimate beneficiary attain the age of majority, the ultimate beneficiary has only a contingent interest which become invested in him when he attains majority. So, where the ultimate beneficiary is already born at the death of the last person, but does not survive to attain majority, the interest does not vest in him, but revert back to the transferor, his legal heir, if he is dead at that time. So, now this is a condition with how it is vested or how it is falling under the contingent interest, because contingent interest will have no hereditary right. Okay. So, it will not go to the legal heir of that. So, what happened that in first condition it has been said that if the in condition of the transfer it has been made that the property will be held by a prior interest person and the property will divest only after the attaining the age of majority. Okay. So, little bit the some concept of the unborn person right is necessary, because in unborn person right we have seen that the unborn person will have right once he came into the womb of woman prior to the death of the prior interest person. Okay. So, if the prior interest person is going to die or has died prior before coming into the womb, then we have seen that no such interest will go to the unborn person. Okay. So, chain has been already broken in that case. Here also it says that it is a kind of contingent interest. Why contingent interest is this? Because it is not vested one. If unborn person right would be vested one, then it would be a kind of right and there was no requirement that there is a necessity to come in the womb. Okay. Any person may transfer the property up to any generation even without the prior interest, because once the unborn person will be given vested interest, then what will be the problem? Problem will be that it will go against the rule of perpetuity. Okay. That means there will be stuck in the alienation of property, transfer and property and all. So, for that purpose, on the basis of public policy for the betterment of this property itself, there has been a condition that there must be prior interest person, that means person must hold the property on the behalf of that unborn person till he is not coming in this earth, plus up to the attainment of his majority. So, here in case condition it has been said that this is the contingent is between the period last person having prior interest dies and the unborn who is the ultimate beneficiary attain the age of majority. The ultimate beneficiary has the only contingent interest. Now, why it is contingent interest ultimate beneficiary? It is till the age of majority. Try to understand. Vested interest comes with certainty. Vested interest comes with certainty. In case of this case, there is no certainty at all. No certainty at all means what? Because he will attain the age of majority or not, it is not certain. Age is certain that okay, if he will alive, then age will come. Okay, in that way it is certain, but whether he will attain the majority or not, it is not a certain event. Okay. So, he may die prior to the attaining the age of majority. Then what will happen? Then it will be not a vested interest. So, here it has been said that unless and until he is not reaching up to the age of majority, till then it is contingent interest. Okay. So, any person, unborn person who came into the womb or is on earth, that means already has came into this world, then he will have only right this contingent right till the age of majority. Okay. So, if he is going to die or if there is he has already died or there is a death of that person, then in that case going to die, I am saying that if there is a certain disease and all, in that case sometimes it happen. So, in that case what will happen? It will be a contingent one, and the property will not go to the legal heirs of unborn person or the person of taking the majority. It will go to the first person who has made that will, that and their legal heir will be entitled for that. So, in that case it is only a contingent interest. What are the nature of this vested interest? So, first of all, it is a present fixed right. Vested interest is the present fixed right to property. On the other hand, where the interest created is contingent, the transferee gets mere future possible rights in property. Contingent interest may or may not become invested in the future depending on the happening or not happening of the incident, just like I have given the example of this person. So, nature of vested interest, but where the interest is vested, accrue the transferee immediately, and the interest may be vested in possession or vested not in possession. Where it is vested not in possession, that means there is a present indefeasible right to future possession, in which case the transferee gets the possession or enjoyment not immediately, but in future. Thus, the vested interest confer a present right to the property, whereas this contingent give a contingent does not give that present right. Only in case of vested right there may be possibility of suspension of enjoyment. Then I already discussed the nature of this vested right. It is transferable and heritable. Heritable I have already discussed, even it can be transferred to the other person, vested right. Then it is a heritability, it is a test of vested right for ascertaining whether it is a contingent or vested. In case of transfer of property, it has been said that the interest of the transfer is heritable and the interest is undoubtedly vested. Okay. So, there should not be problem. Now, come to the illustration. A transfer his property to B and C in equal share to be paid or to be given to them on their attaining the age of 18, and if B and C dies under the age of 18, property shall go to the D. I have already explained. B and C have vested interest, through their interest are likely to be divested upon happening of the uncertain future. Now, contingencies, kinds of contingencies. This contingency or a specified uncertain event may be of two kinds. What are those? First condition is happening or not happening of event depend upon the will and desire of people. That is first condition of this contingency. That means, any event which is dependent on the will of the person, and another is without the will of the person. Okay. So, when it is about the will of the person, then it is about the example has been given that marriage, payment of sum of money in the deed, okay, all these things. So, it will be a contingent one. A makes a gift to B provided C marries within 1 year of the transfer. So, this marriage within 1 year a conditional transfer. Then interest of B until C marriage is a contingent interest. Okay. Then second is where a specified event does not depend upon the will or desire of the parties, that a death of person or before a certain age. Thus, where A makes a transfer of his property to B provided C dies at the age of 40 years, the interest B is contingent. Why? And now you can see the what is the difference between these two. Death is certain, but in this condition C dies at the age of provided C dies at the age of 40 years. This condition is not within the control. Okay. So, it will be a contingent one. If there would have been a condition that property will go after the death of C, okay, after the death of C, then there is a then what will happen? The death is certain, then it will go to vested interest, but here it will go into the contingent interest. Exception to section 21 provide that where a transferee is to get the interest at a particular age, but it is entitled to get absolutely the income of the interest before attaining that age, the interest given to him is a vested interest. Okay. So, exception says that where a transferee is to get the interest at a particular age, that after the age of majority, but entitled to get absolutely the income of that interest before attaining the age, then it is a vested interest. Nature of contingent interest, future possible interest it is. Okay. Then transfer of property where the transferee interest is contingent, he has only a future possible rights in respect of property transferred to him, it is neither present right nor a certain right. Not heritable, it is not heritable, it is transferable interest, whereas it is not heritable. So, since the contingent itself is an uncertain interest in the property, the transfer of owner title is not perfect, transferee to gets an imperfect title. It may be the transferable, but the title will be imperfect title. Now, the last portion of this lecture, that is the difference between contingent interest and space successness. So, I have already discussed about the space successness in lecture number 3. So, what is the main difference between these two, because both are about the condition itself. Okay. So, in case of contingent interest, degree of the possibility is lesser as compared to space successness, whereas space successness or a mere chance of being here apparent is dependent on several possibilities. Example, here apparent survive the propositus, even if he survives the propositus during his lifetime already transfer the property, if he has made a will of that property, so space successness as regarded as a naked or mere future possible interest. Whereas, in case of contingent interest, it has been, we have seen that interest where a property is transferred subject to some specified uncertain future event, there are only two possibilities, namely either it may happen or it may not happen. So, contingent interest is always a kind of a thing that it will not give you a perfect title. Okay. It is about the future event. In case of a space successness is also a kind of future event, but it is more certain in the sense that it is within the family itself. Okay, within the family, whereas this condition is putting by the parties and it is completely a condition which is unknown condition which has been put, and it may happen or may not happen. So, when it will be certain condition, so certain condition will be kept apart and it will go into the vested interest, whereas uncertain condition happening or not happening, if it will be kept in that, then it will go under the contingent interest. So, overall it is about the vested interest and contingent interest, and these are very important for the purpose of bifurcation of the rights, that how a person or that is transferee will have right to enjoy or not, will right to transfer it or not, whether the legal heir will be able to get succession of those right or not. All these things will depend upon the distinction of vested right and contingent right. So, it is all about this. Thank you from my sides. We will meet in the next lecture. Thank you all.